50 years later, listen to this old Wisconsin v. Yoder Supreme Court hearing by Tora Bontrager as the 50th anniversary of the United States Supreme Court case Wisconsin v. Yoder approaches. The 50th anniversary of the hearing, December 8, 1971, leading to the decision, May 15, 1972, has already passed. One of the things I recommend that everyone listens to is the actual audio from the 1971 hearing. It's only 1 hour and 3 minutes long. There were no other hearings. This landmark case deemed children to be the property of parents, like inanimate objects, without any rights, despite the fact that children are human beings and do have constitutional rights and were, by default, parties to the litigation. It took a mere 1 hour to seal the fate of American children who happened to be born into the wrong group of people. Those children were specifically singled out to be denied the right to an education past the 8th grade by the highest court in the United States. Throughout the 50 years since then, the instant they're born, children of practicing Amish are stripped of the educational rights that all other American children are understood to have. Because of the precedent set by Wisconsin v. Yoder, any parent guardian can now point to Yoder to claim the right to also deny their child an education past the 8th grade. It gets even worse. United States citizens, children and adults, don't have the right to any education at all in the eyes of the federal court. This was solidified by Yoder, which overrides any state that has a constitution that spells out a right to education for its residents, including compulsory education laws. The audio of the Wisconsin v. Yoder oral argument, or hearing, is spooky. The old technology from 50 years ago makes the sound of the voices crackle and echo, like an old-time radio murder mystery show during the golden days of network broadcasting before television. That effect is even spookier when I, as a woman, hear nothing but male voices. Not a single woman or girl was allowed the opportunity to have a say in this hearing or be adequately represented in the case. The spookiness is amped up even further when I hear Ball's self-indulgent, fictional account about me, i.e., the Amish. The arguments by William B. Ball, the attorney who won the case for the parents, at the expense of the children, are riddled with fantasies and fetishizations about my Amish people. Ball won the case based on the most incredibly outlandish, illogical, and false claims ever made about a specific group of people. John W. Calhoun, the attorney who lost the case for the state, which was supposed to work in the best interest of the children, argued, on the other hand, in such a mild way compared to Ball who followed after him that it seems, if for no more sinister reason, the case got won by the attorney who dazzled the Supreme Court justices with an oratory performance rather than the attorney who presented the straightforward, indisputable facts. The justices should all be condemned in our history books, classrooms, and courtrooms for betraying the rights of an entire population of innocent children and subsequent adults forever after. The state also needs to be jailed for refusing to ensure that the children's rights were protected, such as appointing them a guardian ad litem. I wonder why the state ever challenged Ball's win at the Wisconsin Supreme Court level when they refused to carry out such basic things as appointing the children their own attorney. Why did the state even bother appealing the decision to the federal Supreme Court? Calhoun couldn't have done a worse job. It sounds like he intentionally tried to lose the case. What backroom deal did he benefit from? Lest it sounds like I have nothing against Ball, I do. He didn't care at all about us Amish and our religious rights. The only thing he cared about was using us as a guinea pig to see if he could get an extreme, that is, unconstitutional, religious liberty exemption pushed through. If he was successful, he could use Yoder as a precedent for demanding all sorts of other extreme, that is, unconstitutional, religious freedom exemptions. As I've written in other posts and articles, this case was never about protecting Amish religious freedom. It's just marketed as such. If you want something truly shocking to hear about a single group of humans, and a decision that directly affects you, too, as you commute, work out, or go about your daily routine, this audio should be at the top of your list. It's included at the end of this post and also on my and the Amish Heritage Foundation's YouTube channels. At any rate, if you're more of a reader, skim the audio's transcript. I edited the transcript for brevity and it's broken down into 3 parts. John W. Calhoun's argument, William B. Ball's argument, and Calhoun's rebuttal. Happy listening reading.